Yes, Mr. Tannock, your second fundamental point.
Thank you, my lords, or perhaps my second basic point, my lord. Well, that is that the scope of the duty of care did not extend to the kind of loss that was claimed. And I'd begun to address this in some remarks before, but what is the scope of the duty of care when driving? Well, simply put, it's to take reasonable care to not damage other vehicles or other road users. And the negligent driver had a duty to Miss Armstead, as he did to all road users, not to damage their vehicles. And this duty did not suddenly vary when he collided with Miss Armstead's vehicle because she happened to be driving a replacement car on credit hire with standard terms, including Clause 16. So the law doesn't require drivers to keep a lookout for credit hire vehicles and take particular care in relation to those for incurring additional liabilities. What the law does is require drivers to take reasonable care to avoid physical damage, and it makes them responsible for the immediate consequences of the physical damage, such as repairs and such as actual loss of use. So there's no duty on my driver to avoid the hire company or Miss Armstead from incurring the deferred daily charge rate. What there was a duty to avoid incurring damage to the vehicle. So while Miss Armstead is contractually liable, for example, to use your lordship's example, for the costs of repair, those costs are not set by the credit hire contract. The contract, for example, doesn't say every time we replace a windscreen it'll be £1,000 or it'll take 3 days at a certain cost, say £145 a day. But the perspective that I'm interested in is the perspective of my driver. Because this is a claim by Miss Armstead against my driver. He's the defendant, Mr Galewski, I think his name was. Yes. He is liable for the costs of repair because the costs of repair are a direct consequence of the accident. He's liable in tort for those immediate physical consequences of the accident. And he's also liable in tort for the immediate consequences of Helphire not having its vehicle available for the 11 or 12 days that it was unavailable. But I say that the contract between Miss Armstead and the hire company doesn't affect my driver's obligations, and nor does it affect the extent or the scope of his duty of care. And the authorities are clear that the purpose of the duty of care is informative with respect to what the scope of the duty is. So what's the purpose of the duty? Well, to avoid physical damage. It's not a purpose to avoid all liabilities that may be agreed in contracts that relate to the vehicle. And in my submission, it simply cannot be the case that all drivers on our roads are under a duty of care, the scope of which includes avoiding all kinds of liabilities, or indeed the specific kind of liability that was agreed to by the claimant in this case. Because to do so would impose on drivers a liability for any sum agreed in contracts that other drivers may have entered into. And in this case provides an example of that. It would impose on them a liability for sums that are not usual. So in this case, what I say is that the credit hire company, Helphire, was entitled to the interest and depreciation on the asset, and that flows from the West Midlands decision. So that's what Mr Galewski driving along in his vehicle, that's what he should be, that's within the scope of his duty, that's what he should be reasonably foreseeing. He shouldn't reasonably foreseeing that another driver has entered into a contract that reverses the common law position and moreover places that other driver under an obligation to pay much more than the interest and depreciation on the asset while it's under repair, and actually much more than the hire company's actual loss of use. And I'm sure if we were to stop the average person in the street and ask them, do you expect that you would be under an obligation to pay more than the hire company's actual loss of use? You would be required to pay a higher charge rate, which includes additional irrecoverable amounts, they'd say no. So for those reasons, I say that the loss that's claimed, the liability in contracts claimed, doesn't fall within the scope of the duty of care. And I also say it's not foreseeable. And the reason I say it's not foreseeable, several reasons. I've already mentioned how Miss Armstead, in her own witness statement, makes the point that she was not aware of similar terms in other hire contracts. What she says at her paragraph 11 is, my solicitor has informed me that this type of term is commonplace in hire agreements. And what I also noted in that respect was that all three of the other clauses are not credit hire agreement clauses. They are clauses in relation to hire charges. So there's no evidence that these clauses are commonplace in credit hire arrangements. And that's important because, of course, credit hire agreements have additional elements, including the cost of providing credit, which are not typically recoverable. It's also relevant because while there are many hire cars on our roads, there are significantly fewer credit hire cars on our roads. So I don't think it's reasonably foreseeable at all that in any given accident, there will be a replacement hire car after a first accident under a credit hire arrangement, and therefore there will be charges like that in clause 16. Now, what Recorder Benson QC found at paragraph 47 of his judgment was that it was foreseeable that damage to a hire car might give rise to a loss of use to either the claimant or to the hire company. And not only do I think that's right, but I'm sure my learned friend will agree with that proposition. Also in his paragraph 47, he then reminded himself that the defendant doesn't have to foresee the actual damage, provided that the kind of damage was reasonably foreseeable. And that was because, as he noted in his paragraph 47, and I'll read it out, it is, I think, questionable whether a car driver who negligently damages another vehicle, which is a hire car, would reasonably foresee that the blameless driver would be contractually liable to pay a sum to the hire company for loss of use of the vehicle in a sum greater than the hire company would itself have been able to recover from him. What the recorder is saying is that a contractual liability for an unreasonable sum, or for a sum that's not usually recoverable by law, is not a reasonably foreseeable kind of damage. And of course, there are policy reasons here as well. Many vehicles on our roads are the subjects of leasing agreements, purchase hire agreements, other forms of loan agreements, as well as being straight car hire agreements. So is every careless inadvertence when driving that causes physical damage to another car now going to result in the careless driver being responsible for whatever is agreed in any contract that the car may be subject to, or the other driver of the car may be subject to? And the recorder notes this issue in his judgment at paragraph 59. And he says that if this is to be the approach, negligent drivers who cause damage to a hired vehicle would be exposed to considerable liabilities based purely on what the innocent driver had agreed with the hire company, agreements over which the tortfeasor had no input or control. So if so, I think that this could result in a wave of claims in potentially crippling amounts for the ordinary man on the street that have nothing to do with the physical damage. To give a simple example, is a careless driver to be responsible for whatever rate of interest is agreed in a hire purchase contract? Or is a careless driver to be responsible for the acceleration of payments under a hire purchase contract when a vehicle is a write-off in an accident and the hire purchase cost includes the cost of providing credit over the whole duration of the hire purchase agreement? Would a variable rate of interest at, say, 10% above base be consequent on an accident? As is noted in many of the authorities, including by Lord Justice Morbeck in Network Rail at his paragraph 95, the law's long been concerned to ensure that there is some form of reasonable limit placed on the extent of the consequences of a wrongful act. And in my submission, there must be some sort of limit to claims like this. Now, I say that the claim is not a good claim in law because it's pure economic loss, because it's not consequent on the physical damage. I also think that agreements that reverse the common law position and that place innocent drivers under liabilities that they wouldn't normally be under is not foreseeable, not a foreseeable kind of agreement. But even if this is wrong, I think that policy considerations point strongly against extending a driver's duty of care to guarding against such losses. My lords, my third fundamental point, or basic point, is noted at paragraph 17 of my skeleton argument, and that's simply that the claimant's agreement with Helphire doesn't bind my driver, the respondent's insured driver. So in this matter, the claimant and Helphire have agreed a sum that the claimant is to pay Helphire, said to be for the loss of use. Now, we've already been to Network Rail, and we've looked at some of the conclusions of Lord Justice Phil. I think we were taken to his paragraph 68 and 69 in particular. At his paragraph 70, he made the point that making a contract doesn't confer a license on the respondents to charge the tortfeasor whatever types of financial loss and whatever quantification of loss is included in the agreement, provided it is reasonable between the contracting parties. And I'll pick up on this point later, but what's an issue here isn't what's reasonable between Miss Armstead and Helphire. What's an issue here is what's reasonable between Miss Armstead and the respondent's insured driver. What's reasonable as between the claimant and defendant in this case. But in any event, Lord Justice Morbick's conclusion is echoed by elsewhere in the judgment. And I thought I might take you very briefly to the decision of Lord Justice Jackson.
Yes.
And if I could take you, please, to it's tab 19 of the Second Authorities Bundle, page 431. The reason I'm taking you here is the court considers some well-known credit hire cases. And at paragraph 140, the case of Diamond and Lovell is mentioned. That was mentioned in passing this morning.
Yes.
What you see, it says on its face, it was a credit hire claim. The claimant's car was damaged in an accident. The claimant hired a replacement car at enhanced cost from a hire company, which did not require payment before conclusion of her claim. And the House of Lords held that only the normal hire rate, not the enhanced hire rate, would be recoverable. As you'll see, then there's a quote in which mitigation is discussed, another topic that was touched on this morning. But if you turn over the page to page 432, at line B, the mark with B on the left-hand margin, is a sentence starting, the remainder of what she paid was attributable to other matters and therefore should not be included in the cost of mitigation. And in skipping a sentence, the excess cost was not reasonably incurred as the cost of hiring the substitute car. Miss Diamond's right of recovery is limited to the reasonable cost, that is to say, the lesser sum. If you turn over the page then, to page 433, there's another relevant case at paragraph 143. This is Langdon and O'Connor. That's another credit hire case. And this addresses, my lords, the point about impecuniosity that we were talking about earlier. So in this case, the House of Lords held that a claimant could recover reasonable additional charges of a credit hire company if they were impecunious. So if their impecuniosity is such that they could not otherwise have obtained a replacement car. And then the final portion of Lord Justice Jackson's decision that I wanted to take you to was also you also taken to this by my learned friend. It's paragraph 145, where he summarises the common law rules and principles. And the first principle, number one, economic loss which flows directly and foreseeably from physical damage to property may be recoverable. Now, bearing in mind my driver's duty of care to Miss Armstead, my case, well, part of my case, is that the economic loss that's claimed doesn't flow directly and foreseeably from the physical damage to the property. In looking at the Roman numeral 4, in choosing the appropriate measure of damages for the purposes of assessing recoverable economic loss, so once you've decided the loss is recoverable, just like in Network Rail, it was revenue-generating property that was damaged. The loss was an immediate consequence of the physical damage. So now we need to decide what's the measure of damages. Well, the court seeks to arrive at an assessment which is fair and reasonable as between the claimant and the defendant. So even assuming, and this is at paragraph 19 of my skeleton argument, even assuming that the daily hire rate was reasonable as between Miss Armstead and the hire company to compensate Helphire for its loss of use, and I'd say that would be quite an assumption, but let's assume that all the daily charge rate does compensate Helphire for its loss of use, then that wouldn't make the daily hire rate the appropriate rate at which to quantify the loss that should be paid by my driver, who's a non-party to the contract. Now, what Network Rail does, and what Network Rail does do, is it makes the point that the court can and should scrutinise the quantum of the loss that is claimed. It's not for Miss Armstead and Helphire, by their agreement, to dictate to the world and to the poor Mr Galewski to pay whatever it is that they've put in their contract. And with respect to what Helphire's actual loss of use was, well, the fundamental point here is neither Miss Armstead nor Helphire have brought a claim for that, and they've not put any evidence as to what it was. So either Helphire would have had general or special damages in this respect, but it hasn't made its case as to that, and the only basis of the claim is the deferred charge rate in the contract. My lords, those are my three basic points. Turning to my additional points and starting with bailment. Now, in my learned friend's skeleton, at his paragraph 39 spot 1, and in his submissions, my learned friend has said that the applicant's case is based on a principle of tort rather than a principle of bailment. But as I've noted, the way that claimants typically put their cases at the county court level is on the basis that the proprietary fiction in bailment entitles them as bailees to make claims based on versions of Clause 16 in the hire contracts, and that the court cannot go behind that. So with this noted, I'll address you briefly with respect to bailment. And as I note at paragraph 23 of my skeleton argument, the starting point is that for a claimant to have rights to claim, the claimant must either own the property or have possessory title to it, or the owner must be joined to the proceedings. And I think that that's uncontroversial. And I think it's also uncontroversial that as bailee in possession of the hire car at the time of the accident, she had the right to claim and tort to recover the physical damage to the hire car. What we're debating is what additional damages, what additional loss or alleged loss can she also claim for. Now, my lords, the Winkfield was referred to earlier, and the Winkfield is summarised in Morrison Steamship Co., which is in our bundle at, I think it's tab 4. Yes, it's tab 4. And if we go to page 66 of the latest bundle, there's a section there that I've marked in the margin. At the top of that section, it is true that in the case of physical loss, a bailee can sue for the value of the property entrusted to his care, if that property is lost or injured by the tortious act of a third party. But that's not the end of the matter. And if I could take you to Palmer in bailment.
Sorry, which page was that?
Oh, sorry, that was page 66. That was page 66. Behind tab 4 in volume 1. It is true that in the case of physical loss, the bailee can sue for the value of the property.
What that appears to establish, and certainly Mr. Williams submits it does establish, is that the bailee has the title to sue.
Yes, that's right.
What I'm not aware of, speaking for myself, but my lord is very familiar with, is what else may follow, and whether the bailee can sue, for example, for the entirety of the loss, in fact, incurred by the bailor. It may not matter in this case, I don't know, but all this seems to establish is that you have the title.
The title,
to sue.
that's right. It establishes title to sue. That's correct. And what this is only the starting point.
Right.
And the starting point is there's title to sue, and in the case of physical loss, you can sue for the value of the damaged property. And that I think in the old authorities is where we started out in the law of bailment. But then there's some subsequent development. So if we go to Palmer on bailment, and that's in the second authority, and it's at tab 24. From page, from paragraph 4099, I'm going to use the page numbers at the top of the pages, so actually the textbook pages. You see there's a section titled D, the limits of the bailie's recovery, which...
sorry, which page?
It's page 327 of the textbook itself. It's actually page 561 of the authorities book.
Thank you very much.
And you'll see there
we
D,
can't see this. Sorry, what was the page of the textbook?
page of the textbook is 327.
Thank you.
And when you're there, you should see a section D, the limits of the bailie's recovery. So this is the section in Palmer that's addressing the question that my Lord Singh just asked me, is what's the limits of what can be recovered. And I won't take you through it all. But if I take you to page 329, the textbook page 329, so if you turn over another page, around halfway down the page, there's a start of a new paragraph. It says, consistently with such observations, the bailie's possessory interest has been regarded as affording a sufficient qualification to entitle him to sue for those economic losses which, while consequential on the damage to or destruction of the goods, are not reflected in the pure cost of replacement or repair. And then there's the example of the Oakhampton, which I think is which is in our bundle. And then if I could take you to paragraph 108 of Palmer, which is at page 336 of the textbook itself. So that is 6 pages on. And there's a section there that I've marked that starts with first. First, it has been repeatedly recognised that recovery by virtue of the Winkfield is independent of the bailie's own accountability under the bailment. And it continues. Secondly, however, it cannot be assumed that the mere existence of such liability to the bailor necessarily entitles the bailie to transfer it by virtue of the Winkfield to the wrongdoer. For such liability may fall beyond the scope of any duty owed to the bailie by the wrongdoer, as I said it does in this case, and may be unforeseeable by the wrongdoer, as I say it is in this case, and may result directly from the terms of the bailment itself, rather than the actual wrongdoing. Again, as I say it does in this case.
Can I just ask this, just to make sure? You would accept that Miss Armstead could bring an action for the loss of the cost of repairs after the accident,
Yes.
and also for the correct measure of losses suffered by the bailor, which you say is depreciation and interest.
Yes.
Yeah.
But I say that...
And would hold the second tranche, i.e. what you say is depreciation and interest, he says
On
different,
trust.
on trust
Correct.
for the bailor.
Correct, for the bailor.
And I mean, that was all
Yes.
simply a matter of the common law trying to make things simpler, so
Yes.
you didn't have a multiplicity
That's
of
exactly
actions.
right.
Yeah. Good.
If the credit hire company had produced evidence in this case that the car was the only one they had at
Yes.
the relevant branch,
Yes.
they could have hired it out during the 12 days
Yes.
to Mr. or Ms. So-and-so at let's say, £70 a day,
Yes.
would you accept that that loss would be recoverable?
Yes.
And recoverable in the action brought in the name of Ms. Armstead?
Yes, for the convenience reasons that
Yes.
have just been mentioned.
I should have asked this. Are claims of this type ever brought by two claimants, the hirer and the hire company together?
My lord, not that I'm aware of. I think in principle they could be, but I think in practice what happens is what's happened in this case, which is that the hirers are only too pleased not to have much to do with the claim and to let the credit hire company go on with
Yes.
processing the claim and so on. So I think in principle it's possible, and this is where the double recovery point becomes relevant.
Jus tertiae. And Buncefield was an example where they actually joined in the owners to avoid some of the technical points that could have been taken in
Yes.
that particular case, because there was no, or arguably no, possessory rights to the
We're straying a little bit. The Torts Interference with Goods Act also specifically allows a defendant who's faced with a claim and fears that there may be a bail-law with additional claims to join the bail-law to the proceedings. So there's also a mechanism, a statutory mechanism to deal with this.
Yeah.
As well.
It seems to me it would be very odd if the identity of the claimant, or whether it was Ms. Armstead or the company or the two together, should make any difference to the amount that's recovered.
Well, I think, my lord, that's exactly the point, as we're saying we shouldn't. And what it should be is the amount that Helphire could recover from my negligent driver if Helphire were to sue my negligent driver directly, which is interest and depreciation on the asset over the period of repair.
There would obviously be considerable public interest in allowing the hirer in a case like this to claim, because unfortunately, as it happens, Ms. Armstead wasn't injured, and if she had suffered some minor injury, it would be very tedious and bureaucratic to
Yes,
have,
of course, to have separate
claims.
That's right. And so that's one of the reasons I took you to my learned friend skeleton argument, which the point is, in personal injury, she has to bring the claim herself.
Yeah.
It can't be brought by the hire company on her behalf. But anyway, I think we've addressed it.
Thank you.
So continuing with Palmer then, just to finish the bailment story, if you like, if I could take you to paragraph 4133, and that's, if you turn over 2 more pages.
113, you mean?
So 113, my lord.
Yeah.
Yes, you're right. It's this is where the authors mention HL Motorworks and the Winkfield, and I won't repeat myself. I previously pointed out to you what I call the little wrinkle with HL Motorworks that caused the authors of Palmer and Bailment to have concerns about it, which I say has been addressed by the subsequent case law. But the portion I wanted to take you to is the portion, and it's in my skeleton argument. It's the second paragraph. It is submitted that such a conclusion, which is a conclusion that all losses the owner has suffered in consequence of the third party's wrongdoing, even if they're not directly recoverable by the owner from the third party, and possibly where they're not so recoverable, can be claimed by a claimant like Ms. Armstead. And then they say, it is submitted that such a conclusion would constitute an unacceptable expansion of the common law proprietary fiction. The quantum recovered by the bailee should not be permitted to exceed the aggregate of, first, the amount which the bailiff himself could have recovered in person from the wrongdoer, and secondly, the amount, if any, of the bailee's personal loss. And that's my position, my lords. I say that should be the position. And then if you look further down...
Well, I just wonder really how much there is in some respects between you and Mr Williams, apart from the proper measure of damages, because he accepts that he can't enforce this contract to the extent it's unreasonable.
Yes.
So actually, if properly analysed, you're right on your assessment of damages, then he can't enforce it, but perhaps for different reasons. And if you're wrong, he albeit by a wrong device, he would get the same.
Well, I mean, I think what my learned friend said was that if Beechwood applied, he'd accept that the claim was a contrivance, and West Midlands, I say, applies and has the same effect. So in any event, I say that the claim should be limited to what the hire company would have recovered in person, and to her loss. But what's the reason that we're here is that neither is claimed in this case. What's claimed in this case is the amount under clause 16, which is the deferred daily charge rate. So the claimant hasn't claimed for the car hire company's loss of use, actual loss of use, and nor has it claimed for, nor has she made a claim for her loss of use, which we've already discussed and understand. I won't, unless you would like me to, address HL Motorworks any further. But I will instead turn to the final of my 5 points, my sort of second supplementary point, if you like, which is that this is a claim for a relational economic loss. Now, if you accept my submissions that I've made earlier, then I accept that this point may not fall for consideration. But in any event, in case it does, a relational economic loss, in my submission, is a subset of pure economic loss. This is because it's an economic loss that arises not as a consequence of the physical accident, but as a consequence of a contract or a relationship. Now, the way that Clark and Lindsell put this is they say, no duty is owed by a defendant who negligently damages property belonging to a third party to a claimant who suffers loss because of a dependence on that property or its owner. And you'll see that in the second authorities bundle, tab 25, page 5937. It's paragraph 7-152.
May I just ask that I'd always understood how Clark and Lindsell put it as pure economic loss.
Yes.
Rather than relational economic loss.
Okay.
I mean,
well,
I
think relational economic loss is a subset of pure economic loss. It perhaps might become clearer from the Charles and Percy definition, which Charles and Percy, I'll give you the reference for your note. It's the second authorities bundle, tab 26, paragraph 2-233.
Thank you.
And they say, financial loss that occurs only because of the relationship between the immediate physical victim of a wrong and a claimant is conveniently and quite commonly called relational financial loss. Now, this particular passage has caused some confusion at the county court level, as can be seen from the recorder's judgments. But I say the way through it is pretty simple. In this matter, the claimant is obviously Miss Armstead, and the immediate physical victim of the wrong is the hire company, because they've had their car hire damaged. They're the ones who've suffered the damage to the car. So the financial loss that occurs only because of the relationship between Helphire and Miss Armstead is conveniently and quite commonly called relational financial loss, as I would say the way that is read.
But you accept that as Bailey,
Yes.
she has title to sue, at least for the physical damage.
Yes.
So the cost of repair,
Yes.
it's now common ground.
Yes.
So where does this proposition
Well,
get you?
this proposition, in the event you didn't agree with some of my earlier submissions, what this proposition does is this proposition makes the point that the claimant cannot claim a loss that only arises out of a contract or a relationship and doesn't arise out of the physical damage. Now, what I see from my learned friend's skeleton argument is he makes the point that I think your lordship's referring to, which is around possession of the vehicle. And that's an important point. In this matter, obviously, Miss Armstead was in possession of the vehicle at the time of the accident, and that was in 2015. She then handed the vehicle over for repairs, as she was obliged to do by the contract. And she obviously didn't have possession of the vehicle when it was repaired. Now, you'll recall that clause 16 starts with the words, "You will on demand pay the lessor." Some years later, in 2018, she was provided with a demand. Now, you can see that demand in her, attached to her witness statement.
Can we put the textbook extract away?
I didn't have it, so I was looking up for you, my lord. I apologise, I'll look it up quickly. Yes, it's Exhibit LA3 to a witness statement. It's on page 19 of the supplementary bundle. And it's a demand dated 14th March 2018 for damage on the 23rd of November 2015.
Well,
So at the top,
that's when the demand is made. I see
Yes.
that point. But the demand, well, doesn't one have to ask what is the demand for? What is it in respect of? And it's in respect of the number of days when the vehicle was unavailable for hire due
Yes.
to damage.
yes.
So why isn't that consequential upon physical damage?
Well, my lord, for the reasons that I've given you earlier, it's the amount of that loss, which is the daily rate of 145.30,
Yes.
yes, isn't consequent in my submission on the physical damage.
No, those points you already made.
Yes.
I understand that, but I'm not
Yes.
sure at the moment. I'm not understanding how relational economic loss.
I see.
has got anything
I
to
see.
do with
Yes,
this.
my lord. So, my lord, the point in relation to relational economic loss is, at the point that the demand is made of her, some years later, and at the point that her liability to pay under clause 16 is triggered, she is not a bailee of the vehicle anymore. She does not have possession of the vehicle. So, this is a loss that at that point in time is a loss that's arising as a result of the relationship of the contract. It's not a loss that's arising as a result of her possession of the vehicle as bailee. So it's a relational economic loss point.
You might also get to the same analysis by looking at what the Master of the Rolls said in Wingfield, which is that you're not bothered by the private contractual arrangements made between
Absolutely.
bailiffs and bailies.
So, my lord, we had the Wingfield in the appeal below.
Yeah.
For some reason, I think because we thought that the principles were agreed, it didn't make it into this bundle. But you're right, and I think that has to be right. I think. Just by way of completeness with respect to relational economic loss, the case of London Waste Limited versus AMEC, which is at tab 38 of the bundle, confirms that the rule against relational economic loss hasn't been displaced by subsequent developments in the law of tort, particularly Caparo. And for your note, starting at paragraph 9 of that judgment, moving to 13 and concluding.
Sorry, which judgment was that?
It was London
Going a
Waste.
bit too fast. We'd better have a look at the.
London.
London Waste.
Thank you.
In its paragraph 9,
Sorry, which tab?
tab 38.
No, you've made that up.
There
There is no such thing. I think 15.
I can't see it, yes.
London Waste,
I have.
tab 15.
I have completely. Yes, it's the first authority and the second one. And what London Waste does is at page 324, paragraph 9, the rule against relational economic loss is outlined. And the judge says, I shall call this the rule. And then at page 326, paragraph 18, the judge finds that the rule's not been overruled by the threefold test of Caparo. It still exists. And then, insofar as it's relevant, his conclusion at paragraph 21 is that the rule in this case, in that particular case, excluded recovery. It didn't permit recovery.
But, this was just a case of its time because people misread Caparo as chucking up all the previous rules that had ever been written.
Yes, I think that's right.
And all he was saying was, no, it hadn't, which explains why it continues to feature. And economic loss is as irrecoverable in the 21st century as it was in the 19th.
Yes, I think that's right. So, I mean, my view of the relational economic loss is it's a subset of pure economic loss. But anyway, that's my view. My lords, I thought, in conclusion, rather like my learned friend did, I might take you very briefly through the Khan framework, the 6 questions posed in Khan, and also applied in Manchester. The first question, is the harm actionable in negligence? Well, of course, while economic loss is recoverable in some circumstances, I say that this is pure economic loss and it's not. Even further, I say it's caught by the subset of the rule against the recovery of relational economic loss. Second question, what are the risks of harm against which the law imposes on the defendant a duty to take care? So this is what's the scope of the duty? Well, I say it's obvious. A must take care to save B harmless from physical damage when A is driving. And I think this makes it obvious to my mind that the scope of the duty doesn't extend to the kind of liability that is being claimed.
You must go a bit further than that, because you wouldn't then allow me, if you run me over and I can't go to work for the next month, you wouldn't then allow any damages, because those are economic losses, albeit consequential on physical injury. And you've just restricted it to physical damage.
So, well, no, my lord, I didn't mean to, if that's what I did.
Well, you said the scope of duty was limited to physical damage, which excludes consequential economic.
No, and my apologies, and that was wrong. It's also the immediate consequences of the physical damage, yes.
And economic loss consequential.
Consequential, yeah. Economic loss truly or immediately or directly consequential on the damage, yes.
Sorry.
Sorry, that's
undoubtedly true, but then of course it depends what it's directly consequential
means. Yes, yes, it does. It does, my lord. And it may be that when I think it's Spartan Steel, when the example that I gave you, when the judges use the terms immediately consequential and directly consequential, it may be rather like gross negligence. Negligence is negligence, and gross simply describes that the negligence is of a particularly high degree. It may be that what was meant by those comments and other comments is that the loss that's claimed must be very immediate and very, very proximate to the physical damage and not removed. And I guess that's part of my point, is that I'm saying that in this case, from the perspective of my driver, not from the perspective of Ms. Armstead, the perspective of my driver, that is a loss that's not foreseeable and is too far removed.
Can I just take you back to the terms of Clause 16?
Yes.
In the present contract.
Yes.
I'm just trying to understand what it actually applies to, and I'm afraid it's so small that I can't see it through my glasses. I'm trying to see what it actually covers. As you've pointed out, the liability to pay doesn't arise until the demand is made.
Well, my lord, there's a couple of points there. I think when she signed the contract, she agreed to pay on demand this amount.
Oh yes.
So in that sense, the liability arises when she signs the
contract. But the liability. Sorry, this is meant to be a point in your favour.
Yes, of course.
I think you were making the submission that it was not until the notice of demand in 2018 that she in fact had a legal liability to pay under Clause 16. Right, that I understand.
Yes.
Whether it's right or wrong, I won't say now.
Yes.
But what I'm interested in is whether this is confined to the situation where the vehicle is damaged, or whether it could simply be, it seems on the face of it, to cover the situation where you have failed to return it. And therefore it's...
Yes, my lord. So what it says is that it says you will pay on demand the lessor an amount equal to the daily rental rates specified.
Yep.
In respect of damages for loss of use,
Yep.
for each calendar or paying day, unavailable to the lessor, because, and here are the reasons.
You have not returned it.
Clause 9, you have not returned it. Mechanical failure, except as implies it. And then the last one, or the hire vehicle has been damaged.
Right.
And we're in that final third territory.
Well, we are, as it happens, we are.
Yes.
But your point, I think, is
yes, it is.
that the legal liability to pay doesn't arise because it's an immediate consequence or a direct consequence of the vehicle being damaged. It is that you haven't returned it for one of these reasons. or is that wrong?
My point in this case is that the legal responsibility to pay is because, firstly, the hire vehicle's been damaged, and then it's triggered when there's a demand.
Yeah. Because the point against you might be this: in the real world, let's suppose this wasn't the contract, because Mr. Williams says that there are similar clauses in the ordinary Avis type of car hire. He may or may not be right about that, but let's assume he's right about it.
Okay, assume he's right. Yeah.
Right, so I'm a driver who hires a car from Avis, and it wouldn't surprise me at all if there's some standard clause in that agreement which says that if when I return the car it's damaged, then and if the consequence of that is that it's got to be repaired and therefore will be unavailable for use for a period, I've got to pay the daily hire rate for the number of days when it's unavailable for use because of the damage which occurred on my watch. It would not surprise me if there is such a clause in such agreements. Why is that unavailability not a direct consequence of the physical damage?
So, my lord, unpacking this a little bit, the first point is that this is a credit hire arrangement. It's not a standard Avis.
I know, but I'm asking you about a standard hire agreement.
Oh, you asked about in the standard. I see. Apologies, my lord. So, in the standard hire agreement situation, your question is, why is that not a consequence of the physical damage? Well, the reason it would be a consequence of the physical damage if Avis, in this example, had only one vehicle, or if Avis's entire fleet was booked out and Avis had no replacement vehicles from its fleet, then Avis could then recover the full Avis daily hire rate because they would have no option. They would be losing out on that. But if Avis did have fleet vehicles available, then we were back in the West Midlands situation.
Yeah. So your argument earlier this afternoon, in fact, would be equally applicable to the standard car hire agreement and not just a credit hire agreement.
Yes, but there are a few things here. One of which is, if you actually look at the clauses that are given as the standard examples, and that's on page 3 of the supplementary bundle in Ms. Armstead's witness statement, they're actually quite different to clause 16. So look
Look at Avis on page 23 of the supplemental bundle. You've got F, pay on demand a loss of income charge.
Yes.
Avis will charge the renter at the contracted rate if it cannot rent out the vehicle because it needs to be repaired or is a write-off, etc. So, I mean, the effect, you're right, it's differently worded, but the effect is pretty similar.
Well, if you look at Europe Car, which I'm looking at the claimant's witness statement,
Page
3, damages for loss of use of the vehicle I have a cause, whether or not you're responsible for loss of use. Thrifty is a loss of income charge. And the Thrifty agreement refers to the damage protection program, which is the collision damage waiver point that you were making.
Well, I suppose you are entitled to make the point that everyone has to get effectively the hire car insurance, and whatever their theoretical liabilities, these are simply clauses drafted by the insurer to themselves.
Yes. So, but coming back to the sort of fundamental point, I think it must be right that in the case of, say, Avis, they would be entitled to claim the rental rate in my submission if they didn't have other vehicles available.
I mean, the clauses do make provision, the Avis one does, for you to get your own insurance. And assuming that you have survived the head examination that requires, you can see all the liabilities that follow from them.
Yeah, well, this contract as well, this credit hire contract also requires insurance to be taken out.
Yes, well, it's all right. You need
Paragraph.
to look it up.
paragraph 10, paragraph 11. And there's, of course, the collision damage waiver charge. So,
and the Avis one you've just shown us says Avis will charge rent at the contracted rate.
Yes.
We're not told what the contracted rate is, but I think as we're all giving evidence, we can take judicial knowledge of the fact that it doesn't cost £150 a day to hire an ordinary car in this country.
Yes. So my lord, that's the point around, which the Diamond and Level point, is that there are additional charges baked into the credit hire rates.
Yes.
Thank you.
Thank you, my lord. So I was addressing, I think, the Khan framework, and
You'd gone to 2, you covered 2, and you were on 3.
So this is the breach question. Did the defendant breach his or her duty by act or omission? And if the answer to the scope of duty question is right, then the answer must be no. There was no duty owed that could have been breached to avoid the potential liability. Obviously, there's negligence has been admitted with respect to the physical damage to the vehicle. And so in my submission, the negligent driver would be responsible for the immediate financial consequences, direct consequences of that, including the hire company's actual loss of use. Is the loss for which the claimant seeks damages the consequence of the defendant's act or omission as a matter of fact? Well, in my submission, maybe a slightly silly point, but I think as a matter of fact, the loss that is claimed arises as a consequence of the contract. It isn't coming from or stemming from the actual physical damage. It's quite different to the case if Miss Armstead, after the accident, had gone out and hired a car at the best possible rate available to her. And had she done so, she would then be in the position of Stevens. With respect to sufficient nexus, the question is whether there's a nexus between a particular element of the harm, which the claimant seeks damages, and the subject matter of the duty of care. So there's obviously sufficient nexus with respect to the physical damage of the claim, and that's been admitted and paid. But I say there's not sufficient nexus between the subject matter of the duty of care, the physical damage, and the particular element of harm that is claimed, which is incurring the contractual, the daily hire rate. Then a question about remoteness. Is the particular element of harm too remote, or is there a different effective cause? And in this respect, I just say the loss that's claimed is not reasonably foreseeable, and that's because it not only reverses the common law position, but in my submission it's in an unreasonable amount. And of course, Miss Armstead herself has made the point she's not aware of it. And for your note, although I don't think we need to turn to it now, I think Recorder Benson's summary of the position with the claim, which you find at the judgment, paragraph 45, which is on tab 5, page 49 of our bundle. I think that's a correct summary of the claim. My lords, unless you have any further questions about any of this.
Thank you very much.
Thank you, Donald.
Mr. Williams.
May it please your lordship, just a relatively small number of points in reply. Probably how long the reply lasts depends on the extent to which your lordship would insist you for me to go through the extracts from Palmer, because while they're quite interesting, in circumstances where I've made it clear I eschew any proposition that I rely on some principle of bailment which is enlarges the law of negligence, it may just be of academic interest. And so if your lordships want to move me along on those points when I get to them, I won't feel roughly treated in that respect, if I can put it that way. So far as the core of my learned friend's points are concerned, I think I said earlier, I hope not unpleasantly, that sometimes one felt one was on the receiving end of a blunderbuss. And with great respect for my learned friend, one feels the same as one stands to reply to him. because his submissions consist of putting a series of obstacles in the presence of the claim. But then at other times he appears to make concessions which really do make this sound as if it's really just about, as I've contended, whether or not Clause 16 is actually a reasonable pre-estimate of the liquidated damages. Because, for example, when my Lord Justice Bean put to my learned friend, well, suppose Helphire could prove it had a £70 a day loss of profits. Would that be recoverable? Answer, yes. Would it be recoverable by the claimant rather than having to join Helphire? I also understood his answer to be yes. And that does leave one, if I can respectfully say so, but asking, well, where does that leave all his points that Clause 16 in its current form involves losses which are outside the scope of any duty, are unforeseeable or not fair and reasonable, or even that there isn't any sort of duty of care at all, if on the hypothesis that Helphire could prove a £70 a day loss of profit, the claimant could perfectly well recover it. So I do say with respect that in the enthusiasm to throw obstacles in the path of the claim.
Well, that's his job, isn't it?
Well, of course, but I do. But it's also the job to find coherent answers. And I do say it's difficult to character. And I obviously I'm not here to be anything other than entirely respectful to my learned friend, who, as your lordship has just rightly said, is doing his job. But it's also my job to say if some of the argument you hear appears to lead to outcomes which don't seem to cohere together, because my learned friend's concession that if Helphire could prove a £70 a day loss of profit, the claimant herself could perfectly well claim it. I mean, that really does seem to suggest that the only issue, therefore, in the case is actually whether or not Clause 16 is reasonable.
Well, so suppose that Helphire had been the claimant. What could they have recovered and why?
They could have recovered their loss of revenue.
Yeah, but there's no proof that they lost any revenue.
Well, I'm going to come to that clearly.
Right. Well.
So let me then deal with the West Midlands case. And my learned friend's points on that. Now, the first point is my learned friend's whole presentation of the West Midlands case, so it skips the fact that this case is about what the claimant can recover under the liquidated damages clause. The whole point of liquidated damages clauses, and on that premise, as per Network Rail and the contractual liabilities which were the source of the claim in that case, we say that the only point that in fact arises is whether or not Clause 16 is reasonable. Now, in asking whether Clause 16 is reasonable, my learned friend says, well, if Helphire was bringing this claim as against its bailee, absent the liquidated damages clause, there would need to be a dispute, which somebody might end up paying the costs of, in which one would need to get into issues about what other vehicles did Helphire have available across the United Kingdom, what was their usage ratio, and matters of that sort, which would give rise to substantial disclosure burdens and consume a great deal of the parties' resources. Now, my lords, at the risk of teaching you to suck eggs, that's just the sort of micro-commercial dispute that liquidated damages clauses are introduced into contracts by parties to avoid. They avoid the need to get into those issues by the parties stipulating that if X occurs, this would be the compensation which is payable. Now, as I've readily accepted, as between claimant and tortfeasor, it is always open for the tortfeasor to say, well, actually, the liquidated damages clause which you have stipulated in this case is unreasonable. And that is there is not a liquidated damages clause. That's essentially the point that Lord Justice Pill in particular emphasises in the Network Rail case, where although he says, of course it is worth remembering, Lord Justice Pill concurs in the result because he concludes that the contractual clauses in that case are reasonable, but he does say that clearly the fact that in that case the contractual clauses were reasonable does not give parties carte blanche to stipulate for unprincipled contractual outcomes with a view to mulcting third parties. And that's a proposition which I have accepted throughout my submissions.
I think you misunderstood the question I was asking. When I was asking, suppose Helpline had been the claimant, I don't mean against Miss Armstead. I mean against Mr Galewski or the Royal and Son Alliance. What could Helpline have claimed in this case, and why?
Well, I mean, my first answer to the case is that is not a relevant question because this is not a claim by Helphire.
How can they be better off by using Ms. Armstead as a puppet?
Well, I would suggest that is a mischaracterization of the scenario. They are not using her as a puppet. I mean, there may be all sorts of circumstances in which, if a bailee were to sue for loss of use, the measure of the recovery that the bailee would get would not be the same as the bailor. I mean, for example, I think we actually saw an example of that in the passage from Palmer. My learned friend showed you where Palmer suggested the position as between the bailor and bailee in that case might be different, because whereas in that case the bailee might have had an incentive to pay a more generous measure of damages because it wanted to preserve goodwill, the bailor would not have had that incentive. And there might be other cases where, for example, the bailee is in a much less good position to mitigate loss than the bailor, or vice versa, because, for example, one of them is just in a commercial position or a financial position where they can't readily mitigate, and the other one would have been able to mitigate. And as we've seen in this case, if Mrs. Armstead, which she didn't on the facts of this case, but in another case she might have done, had suffered personal inconvenience, if she brings the claim for loss of use, the measure of her loss would have been personal inconvenience, which would have led to a sort of solatium on a general damages basis of whatever it might be. Whereas the claim by the bailor would be a loss of profits claim, and it would be quantified in a completely different way. So there are all sorts of... So I don't accept that there is a sort of elegance issue where the outcome must always be the same, depending on whether the bailor or the bailee brings the claim, which I think to some extent underpins the problem which your lordship is putting to me, or the perceived problem which your lordship is putting to me.
Can I go back to the same question? Suppose Clause 16 had never existed, and Helpline bring a claim in tort against Mr Galewski or the insurance company, saying by your negligent driving you damaged our car. You've got to pay the cost of repair, no problem about that. But what else could they claim? As a result of your negligence, the car was off the road for 12 days. And you say, and therefore, we are entitled to claim against you £145 a day.
Well, if Helphire's case is that but for the accident, we would have earned £145 a day, which the accident prevented us from earning, then the answer to that question is yes.
Yes, but you say they don't have to. They don't have to prove that. They can simply point to the clause and say, we have decided that we suffer a loss of £145 every time one of our cars is off the road, even though on the facts of this case, Ms Armstead had already hired it back, and there's no evidence that it was the last car left in the branch.
Well, I mean, the reason there is no evidence of that is because it's never a point which was ever put into contention. And I'll come to the fact that none of this is pleaded. It wasn't before the Deputy District Judge. It wasn't on first appeal. It's not in any respondent's notice. It's that this point about fleet utilisation has appeared for the very first time today. Now, and of course, if some point is canvassed in that respect, then a criticism might be open to the party that doesn't address it. But I mean, it is something that has been thrown out for the first time today in response to me pointing out that the use which the recorder made of the Beechwood case, which was all about non-revenue earning assets, was misconceived. So I can't accept that there is any legitimate criticism for the fact that there is no evidence before the court about usage rates. But in any event, if I can just step back, my proposition is that it is fundamental that this is Miss Armstead's claim. Mrs. Armstead's claim is based on her Clause 16 liability. That should succeed unless Clause 16 is unreasonable. Now, the first point to make is the defendant, although it has reserved its position in other county court proceedings, has said in this appeal, in its skeleton argument, that it does not take any point on reasonableness. That is its skeleton argument. Paragraph 42. which is, I think, it's well, maybe your lordships have taken it out of the bundle. It's page 152 if it's still in the bundle. The skeleton notes that well, it says the recorder concluded that the clause was unreasonable. I don't think that's right. But he declined to find it was a penalty. To the extent it's an issue, but for clause 16 in Helphire standard terms, the consumer would not have been liable for this loss of use at all. And but for that clause 16, neither A or R's driver would have been liable in respect of the daily rate of hire. In the premises, although the respondent advances no positive case in this hearing, the respondent has consistently taken the position at county court level that clause 16 would most likely be unreasonable with respect to Mrs Armstead and subject to statutory control. So, I mean, it is, I mean, it's been specifically eschewed in this appeal, and the recorder himself, in fact, doesn't accept the defendant's arguments about clause 16 being unenforceable. And one gets that page 57 of the core bundle in paragraph 73 through to 76. And he also makes the point that in any event, that's not the basis on which Deputy District Judge Fawcett had decided the case. So, I mean, this point is not a point that's decided at first instance. It's not raised by respondent's notice in the first appeal. It's not raised by, if the recorder doesn't accept it anyway, it's not raised by respondent's notice in this appeal. And then when we get the skeleton argument, they actually say in terms that the respondent advances no positive case in this respect.
But that's because, and both of you take pleading points against each other. What he says is, you have deliberately avoided getting into this because you have pleaded only the contractual liability. I'm entitled to say, aha, that's economic, notwithstanding my questions to him about what he accepts the bailee might claim. And you're entitled to say, well, he didn't plead that was an unreasonable penalty clause or pursue that, because he says effectively that's not the proper measure of loss in this case.
Well, he does say that, but I mean, I suppose all my point simply reduces to if you want to say as an entire that clause 16 is unfair because it enables Helphire to recover something in without giving any account at all as to the fact that this car may sometimes have been idle.
Well, what any advocate doing this type of litigation would say was, first of all, you're charging £145. That's not the basic hire rate, and no one's going to give evidence about what it is. But it must be higher because this is a credit hire agreement, where we're supplying the contract to the claimant and we're also covering all the litigation so that we get it back.
Yes.
So there are two aspects which would make it higher than normal.
Well,
that would suggest that if you're charging that as your cost of your loss of use of the car, then it's automatically a bit high. Secondly, he will say it is obvious that any credit company will, any hire company will have more vehicles than normal, save in unusual situations, and therefore you're avoiding getting into all the ratios of usage that you talk about, because you're just trying to make her sign something that she didn't even read. So that you can inflate your claim.
Yes.
And that's why we're going to hit you at a higher level of generality. And you can't complain about my pleading because you didn't bother pleading anything.
Well, I mean, I'll clearly, I don't...
And a plague on both your houses, as it were.
But it's always, in the cases like this, the Mercutio's riposte, I know, is always very attractive. But if I can just unpick a little bit of that. The first point to say is that it's obviously very beguiling to say, well, it just stands to reason that credit rates are higher. I mean, that is not the position that this court has taken in the authorities. And I did say earlier there was a case which we had taken out of the bundle that said this, but I've since realised it's said in the Stevens case as well. And I'm not going to invite your lordships to turn it up unless you want me to, but it's paragraph 16 of that case, which is at tab 21. So it must be put in evidence. Now, the proposition that it doesn't cost £145 to spot hire a car in this country, I mean, obviously that's true if one is talking about a sort of Ford Focus or something like that. I have to say I've got no idea about how vibrant the spot market is in
Mini Coopers,
in Minis, some of which are these days expensive, and if you'll forgive the colloquialism, pretty flashy cars. But the next point is, however, but even if that's right, and even if contrary to the authorities, one just assumes, well, it must be inflated somewhat. That isn't an answer to the point, because as a loss of profits claim, there will be, as I've suggested already, many cases where the hire company would recover more than the BHR because of the impecuniosity exception, which is, as I've said previously, and I apologise for that, that is not some sort of marginal case that almost never arises. I mean, a lot of people in full-time, where you've got two wage earners in full-time work, they suddenly have to find, let's assume the spot hire rate was £50 a day. Suddenly finding £50 a day out of your taxed income at no notice, very, very difficult for lots of working people in this country. So there are going to be lots of cases where, in fact, the hire company wouldn't just get the BHR. And so, again, it's a non sequitur with respect to say, well, therefore, it's an overstatement. There are other ways in which, in an attempt to make the liquidated damages clause fair, I would suggest that it is drafted in a reasonable way. The first thing is its limitation to 30 days. Now, obviously, there will be many cases where repair takes much longer than that, but the hire company only gets 30 days. So it's a sort of rough with the smooth. So perhaps there might be arguments about usage, but equally there'll be other cases where you get more than 30 days. But there will be some, and I know this might be thought sort of slightly commercially unattractive, but it's unquestionably true in the hire industry that although there may be some days, I accept that one might be able to infer that where a car will be idle, but there will actually be other days where it gets turned around on the same day. Certainly, I'm not talking about, I can't say anything for Helphire, but if anyone seriously thinks that sort of airport depots, if you drop off your car at 11 o'clock in the morning, you pay for the day, because you pay for day or part of the day, that car's not often back on the road at 2 o'clock being charged for the second time that day, you would be sorely mistaken. So there will be cases where in fact on some days you get nothing, but on other days you may get double. Well, what I'm simply proposing is that as between the claimant and the defendant, looked at in the round, this is an attempt simply to avoid all these sorts of arguments, which, in just the same way as the clauses in the Network Rail cases would have been about avoiding arguments, avoiding sort of, that obviously would have been massive commercial litigation, tortuous disclosure and such, like the parties simply contracting for this will be the position. And I say, bearing in mind the 30-day limit and the other points I've just made, and bearing in mind that if not in all cases, then in many cases, in fact, the credit hire company would recover the contractual rate rather than the BHR rate. As between the parties in this case, there is no reason to conclude that the rate is unreasonable. I'm so sorry, the clause is unreasonable. I mean, that is the point that I make. It is and as I've said, this is not some contrivance because this is a credit hire company which sort of pushes the boundaries in what I think Lord Justice Aikins called the secular war, which has lasted for 2 decades between credit hire companies and motor insurers. This is, as we have seen, a relatively industry standard clause, irrespective of the source of the hire car, whether it be a conventional hire company or not. And what the hire companies are doing, in my respectful submission, is precisely what parties with liquidated damages clause always do. The whole point of them is to crystallise a dispute, is to crystallise a loss so the parties don't need to dispute about it. And in my respectful submission, that captures the third party's liability as well, essentially for the reasons given on Network Rail, unless the third party can convincingly say that it's unreasonable.
The fundamental submission that Mr. Tannock has made is that your submissions in opening the appeal this morning about Beechwood are just wrong. And he says that West Midlands and Stevens also support the proposition as to what the position of the Bay law would be.
Yes.
Now, what do you say directly
yes.
in reply to
yes.
that? That's a fundamental
yes.
difference in
yes.
law between both sides.
Yes, I agree. Well, you know what I say about Beechwood? So far as Stevens is concerned, I know that's not a case your Lordship have looked at yet, but I will submit that if you do look at it, it's got nothing to do with that point. Stevens is simply about what is the basic hire rate. And before Stevens, there had been a great deal of debate as to whether, because as your Lordships will appreciate, it's a classic example of something that sounds very good in the ivory tower of a courtroom. Various courts say, oh, you get the basic hire rate. Then it turns out that because the car hire market is so volatile and untransparent, you can actually, on the same day, find that very similar cars are going for radically different prices in similar locales. And so that leads to a great deal of litigation over the years where do you get an average? Or because it's a sort of mitigation point, do you just have to show that so long as your rate would be somewhere in the bracket, it can't be unreasonable between the parties, or do you get the lowest rate? And Stevens finally decides that you get the lowest mainstream rate. So that's what it decides. It's about the quantum of the BHR. It's got nothing to do with this issue. I submit, and one doesn't really need to look further than the headnote to see that. So far as the West Midlands case is concerned, my first answer to the case is that it's not in point because it's not a case about a liquidated damages clause. The question is the liquidated damages clause reasonable, unreasonable? That's the question I've just been addressing.
But with respect, you've been addressing it rather as though the question is it reasonable or unreasonable as between Ms. Armstead and Helphire?
Yes, that's what I say is the test.
Well, right, and that's the only test. And if it's reasonable as between them, then it is ipso facto recoverable in a tort action.
Yes, because it is because the liability, and that's the points that I've already addressed under my going through my six questions in the Manchester Building Society case. In a tort action, it's a perfectly foreseeable financial consequence that if you smash into somebody's car and damage it, that may lead to them incurring liabilities to third parties. Both under the Hughes and Lord Advocate principle, that in fact, and the principle that we saw in Elmer's case, that in fact all you need to show is that consequential financial loss is foreseeable. And once you've shown that, it doesn't matter the precise form it takes. Further than that, I say that in any event, even if that is too broad, in modern social and economic conditions, it is perfectly foreseeable that if you smash, lots of people are driving around in hire cars, even more people are driving around in lease cars and contract plan cars.
I'm really sorry.
Forgive me, my lord, yes.
No, I'm really sorry. I have to go back to a question my Lord Justice Bean, I think, has put to you a number of times, and it's my fault. I still haven't understood your answer to this.
Well, then it's my fault.
Forget about Clause 16.
Yes.
Suppose we live in a world where there is no Clause 16, and the credit hire, car hire company, whatever it is, it could be Avis.
Yes.
For my purpose, I don't care.
No, let's assume it's Avis, because then we sort of
standard car hire agreement, right? The owner of the car sues the negligent driver directly. What can they claim for under this head of loss, and why?
Well, under this head of loss, they claim for their loss of profit resulting from the deprivation of their profit-earning asset.
Right, and the submission made against you is West Midlands holds, Beechwood holds.
Well,
it's not that.
Well, Beechwood clearly, in my submission, clearly doesn't hold because that was not about profit-earning assets. So far as the West Midland case is concerned, the only proposition that shows is on the facts of that case. The evidence was that a bus company operating 11 depots in relatively close proximity in the West Midlands kept a fleet of replacement buses in order to provide continuity of service for passengers on its routes if one of those buses came out of action. And so there was no assertion in that case ever that there was a loss of profits. I hope not to go back to it, but if one does go back to it, you'll see that was not a contest between loss of profits and a Beechwood measure of loss. What the bus company said in that case is we ought to get the cost to us of maintaining our reserve fleet. And so they claim their overheads and so on of running the reserve fleet.
Is there any authority which supports your proposition that what they are entitled to claim for is the loss of profits because it's a profit-generating asset?
Well, the usual measure of loss, if you are deprived of a profit-earning asset, is a loss of profits. That is that.
What's the authority?
Well, I don't think there is a case about it in our bundle, because the issue has always arisen precisely in the context of chattels like light ships, or in the bus company case we've just seen the reserve fleet of buses, precisely because there couldn't be a claim for loss of profits. And so the debate was, well, what is the alternative measure of loss if you can't bring the conventional one? But I mean, the usual principle, it's a bit like a taxi driver. If a taxi driver's car is smashed up, I mean, his basic measure of loss on the authorities is his loss of income from his taxi business.
There's nothing wrong with that. That's basic law of tort.
Well, it is.
The claimant is entitled to be put in the same financial position as he, she, or it would have been if the defendant had not crashed into the asset.
Well, precisely, with respect, precisely. And that's why, when I showed you the whole...
But the claimant has to prove actual loss.
Well, the claimant would need to do that. Firstly, if this was a claim by Helphire, which it's not, the whole point of Clause 16 is it dispenses with that by pre-contracting for a formula which crystallises the loss, which is, and unless that formula is unreasonable, you say that's the end of the point. And I know I've made that point quite a few times, but it's important. I do sort of point out to your lordship that in this case, that is, I submit, the answer. Of course, in the counterfactual case, I mean, if this was where Helphire, let's keep it at Avis to avoid issues about DHRs and so on. If Avis sue an RSA insured and they say this is our loss of profits, and the RSA insured says, well, we don't agree to that, we put you to strict proof, then that is a case where, regrettably, I entirely accept what you're going to bring into contention are issues like what are Avis's overheads, and what is the rate at which Avis cars lie idle. But it'll also bring into the counterpoints, but what are the days when Avis, in fact, earned from that car twice in a day, because it's let out twice in a day. And you'll bring all that into contention. And obviously, the first thing that will happen is the case will come off the small claims track immediately, because it will require extensive disclosure and such like. Your lordship is shaking your head. Perhaps I don't understand why.
All you would need in a case like this is a statement from the whatever it is branch manager of the hire company saying this was the only one we had in stock and we.
But with respect, my lord, it doesn't work like that. First, the branches, if Tunbridge Wells doesn't have a car, then they're bringing a car from the Maidstone branch. I mean, it's not. It really isn't as simple as. It's not as simple as that.
Give evidence of that. Anyway.
Well, I hope. Well, with respect to your lordship, you're putting something to me that is posited on an evidential assumption, which is that it's just you just have to look at one branch, and I would respectfully submit, certainly with a nationwide hire company, that would be a false assumption. And certainly, in the West Midlands case, that they refer to the 11 depots and such like. So, sorry, I mean, forgive me if I seemed curt, your lordship. I certainly didn't mean to, and I apologise if I did. But I just venture to suggest it's not as simple as your lordship puts it to me. It potentially actually is quite a complex exercise. You're saying to a large national hire company, well, I don't accept that you would get your daily rate of hire because I think that a lot of the time your cars are lying idle. I mean, you do potentially bring into contention quite a lot of evidence. You do bring up issues that require disclosure. Now, that might well be entirely appropriate. It's likely to be completely disproportionate to the value of these cases, which is, again, why I say having liquidated damages clauses are, in fact, in no sense a negative thing, unless they can be shown to be the sort of contrivance which my Lord Justice Singh put to me this morning, which I say this isn't. And clearly, an awful lot of this case turns on whether I'm right or wrong about that. And that perhaps takes me back to Lord Justice Singh, my Lord Justice Singh, putting to me, what do I say about the West Midlands case? Because I don't think I've actually got beyond my first point, which is that the first point is because this is a liquidated damages case. It's not a strict side-by-side comparison.
All right, that was the first point. We'd better let you get on to the
well,
second.
I'm hoping to. And well, so far as the rest of it is concerned, I simply say that although West Midlands certainly doesn't, the proposition West Midlands did not establish any sort of proposition that where you have got a profit-earning chattel, you only get the Beechwood case. As I say, the West Midlands case was predicated upon the chattel in question not being profit-earning because it was a reserve bus which simply replaced the bus that was unavailable. And as I say, they never claimed a loss of profits. What they claimed was the cost of running, a contribution towards the cost of running their reserve fleet. Now, there is no suggestion whatsoever that any hire company behaves like a bus company, which is simply serving regular routes in a defined geographic area and keeps sort of fleets of reserve cars. Now, I'm not saying that it wouldn't have been open to the parties to investigate this, and I think at one point my learned friend was asked, well, who do you say the onus is on? And I do respectfully say that on the question of onus, it must be for the party contending that here clause 16 is inoperative, because it unfairly overstates a supposedly liquidated loss into something that is much greater than that, or is a contrivance, at least to establish transparently the grounds on which they say that is the case, so the parties can put in evidence if so advised. But if one looks at the defence in this case, as I said before, it was simply never put in contention that, oh, there's a problem here because you're not giving credit for the point at which the cars are lying idle. And as I said, that's not part of the Deputy District Judge's decision, the Recorder's decision. There are no respondents' notices. It's a new point today. And in my respectful submission, it's simply not a point that could be introduced at this stage to say, oh, well, the Recorder may have been completely wrong about Beechwood because he missed the point that this was a case about a profit-earning asset. But there is, in fact, some other authority that leads to the same answer, even though that authority isn't, in fact, on proper reading a case about a profit-earning asset either.
Does your submission amount to saying that a liquidated damages clause is enforceable against the tortfeasor, even though they're not a party to the contract? No,
it doesn't. But what it does say is if, and obviously I only get to that question if, under the normal law of negligence, it is potentially open. But on that hypothesis that it's been accepted, it is foreseeable that a claimant may be driving a vehicle which belongs to someone else and therefore incurs financial liabilities to somebody else. Her prima facie measure of loss is therefore that financial liability, and that's essentially the Network Rail case. But what it does leave open is the question, yes, but is the financial liability incurred under arrangement, which, because of its outlandish or extravagant, or rapacious nature, or simply unfair nature, because it's not individually negotiated, and the sort of points my Lord Justice Dingemans puts to me, it leads to a recovery which is which would not be reasonable as between the parties, the claimant and the bailee and the bailor. And that I do repeat in my respectful submission is consistent with the approach of the court in the Network Rail case. There's no suggestion that if on the concession that the agreement is reasonable, the only question the court had to decide was were the liabilities under that agreement recoverable under the ordinary law of tort. But once it concludes they are recoverable under the ordinary law of tort, there is no then sort of separate analysis that okay, well, even though they're reasonable as between the train companies and the Network Rail, are they also reasonable between the claimant and the defendant? Because once they're reasonable between the bailor and the bailee, then the bailee's loss is the bailee's loss, and so long as it's not remote or such, like, why doesn't the bailee recover it?
Because when you're talking about bailment cases, and we are, you are not bothered by the private contractual arrangements between the bailor and bailee, and that goes back to 1902. And therefore, although they didn't explain why they pleaded it, they said clause 16 is unenforceable. It's because it's you privately, Mrs. Armstead, and you privately, Helphire, who've agreed this, and it's nothing to do with what you can pass on. You're entitled to present yourself to RSA's insured as one person, and lots of good procedural reasons for doing so. But just because you make a private arrangement where you come to a clause which may be reasonable, maybe a reasonable pre-estimate of loss, in which case, fine, you're going to get it properly. But that can't be your cause of action or your loss for this claim.
Yes, well, I think that, with respect, my Lord, takes us back to the difference between your Lordship and myself that we've already identified, which is, and obviously I'm entirely cognizant of your Lordship's knowledge in this area. As I say, my understanding has always been that the importance of the Winkworth principle is the title to sue point, or the locus standi point. But the whole point of the principle is having got title to sue, you simply treat the claimant as if she was the owner, and being treated as if she is the owner, she is in precisely the same position legally as an owner like Network Rail, and you do say, well, as the owner, have you, as a result of the accident, incurred contractual liabilities as third parties? Yes.
But they're not third parties. They are those
that might be
within the private relationship. But you've made your submissions on that.
I have. And what I would say with respect, and I'm sure no doubt your lordships will look at this during the reservation of judgment, the very stark principle that your lordship puts to me, which is that the principle in the Winkworth essentially elides the bailey and the bail-law and treats them as one. I mean, certainly that is a proposition which seems to be entirely absent from those passages in Palmer on bailment, which my learned friend has been citing to you, because it certainly isn't treating.
Well, I appreciate that, but this is because, as far as I'm aware, the first time that anyone has tried to set their head of loss as being what they owe the owner, in terms of the bailment and Winkfield. But I mean, you may be right.
Well, as I say, I mean, certainly, Palmer analyses separately what the bailey can recover and what the bail-law can recover, and there's no suggestion that that is a vain question. So, obviously, in any sort of contest on the law of bailment between myself and your lordship, I would have no.
If anyone had any monopoly of wisdom in this, it's certainly no one here. It's just struggling to try and deal with that on principle.
My lord, I do understand, and you'll appreciate that. All I was intending to say is that the point that your lordship is putting to me is one respect I entirely understand. But I would, with respect, I would respectfully suggest that it is not. You're not putting to me as a sort of established paradigm point in the law of bailment, which I have simply, through ineptness, missed. I mean, certainly as I read it, the point, the sort of very stark point your lordship is putting to me, that this is not even a distinction without a difference. It's not a distinction at all, because they're simply treated as one and the same. I mean, that is certainly not something that I have divined from the very extensive passages in Palmer, which my learned friend has put into the bundle, and it's clearly an enormously respected text in this area. It's right to say that I haven't really looked behind the passages that my learned friend relied on, precisely because I'd always taken the view that the sort of proprietary fiction point was in fact something of a distraction, and it was really simply about, do you get this under the ordinary law?
Well, there's a lot of force in that, and actually there's a lot of common ground between you.
There is.
But there are obviously important distinctions.
Yes,
still.
indeed. Yes. So I'm near the end. Forgive me, I was hoping to be short, and I have, but I have, and I appreciate that there's been a certain amount of repetition, for which I apologise. My learned friend's first fundamental point, that the cause of the loss was not the accident because the agreement was reached before the accident. I do respectfully say that, firstly, that's illogical. The contract provides for payment if damage occurs. So if the damage occurs, that's the cause of the loss. And secondly, it just is inconsistent with Network Rail and Elmer, both of which involved claimants claiming contractual liabilities under pre-existing contracts that crystallise as a result of subsequent motor accidents. And it's worth remembering those are specifically motor accident cases. They're both cases where a structure is damaged by collision with a commercial vehicle. So, and so far as my learned friend's point about the scope of the duty of care, he didn't always distinguish between what are two distinct points. I mean, there's first the question of, is there a duty of care, full stop? That of course, in our respectful submission, is obvious in a road user case. There is a duty of care. There's then the scope of the duty of care point, which is whether or not the damage in question falls within the scope of the duty which there is. And I showed you earlier the passage in Meadows which just treated it as axiomatic that in personal injury claims or road traffic claims, if you damage someone or something physically, you can claim resulting financial loss if it's not too remote. And so, notwithstanding the way my learned friend put the case, I do say very respectfully to him that he is in fact eliding two distinct things, and when you diselide them, you actually see there just isn't a point in respect of either of them, because there's obviously a duty of care, and the duty of care in question obviously encompasses consequential loss on physical damage to property. And the only real issues are the issues that, in fact, we spent the first part of my reply debating, and not these issues. So far as this point on relational economic loss is concerned, I do. Firstly, as to the timing point as to when does the loss accrue, is it the demand, which my Lord Justice Singh and my learned friend debated for a short period. In my respectful submission, that's to start one stage too far. The clause 16 liquidates the damages which are caused for breach of prior clauses. The prior clause here that's relevant is clause 14. That's the clause that you have to deliver up the vehicle in the condition that you received it. So the breach occurs when you the loss to the claimant, to the point at which the claimant becomes liable to the car hire company because of the accident, is the point at which the vehicle is either damaged or arguably when it's returned, but it isn't later than that. But in any event, in my respectful submission, I mean, his points on relational economic loss really do seem to be difficult to reconcile with the Winkworth principle, because he really does seem to be saying, well, it's because the claimant is a bailee. Well, but Winkworth says that doesn't matter, and we all agree that's what Winkworth says. And it is also, with respect, really quite difficult to reconcile with the rightful concession that the cost of repairs were recoverable by the claimant, because that surely is as clear a concession as anything, that the claimant did suffer physical damage to her property, or property which the law treats as her property for the purposes of a negligence claim because of the principle in the Winkworth. And so in the light of that, my learned friend's sort of closing peroration with his six replies to Manchester and Khan, I'm not going to go to the 6 questions in the Manchester and Meadows cases. I'm not going to go through all of them. I simply, with respect, say that he has the answer to them, or most of them, wrong, because this isn't a pure economic loss case, because it arises out of physical damages to property. For the same reason, it's not a relational economic loss case. There is clearly a duty of care in respect of the harm. I've already addressed you as to why we say, and moreover, financial loss resulting from the damage to the vehicle is also is a loss which is within the scope of that duty. I've already addressed you also as to why I say causation is established, because but for the accident damaging the car, clause 14 would never have been breached, and none of this would have been triggered. And as to the issue of remoteness, again, I've already addressed you as to why I say this isn't too remote. My lords, those are my submissions. I think.
Can I just ask one final factual question?
Of course, my lord.
And it may be that if one looks at the damage that was caused, pages 11 and 12 of the supplementary bundle.
Yes.
And what the work was. I mean, we know from the particulars of claim that the careless driver pulled out from his car parking space seems to have caused damage to the left-hand side of the vehicle. It was just that there is here, it says, damage on inspection, undrivable, unroadworthy. It's page 11, bottom right. I imagine that the reason. I just wanted to make sure that you were right. You were both agreed about the factual situation, that she had driven it and then handed it in, because she may have thought it was fine to drive, but a mechanic may have thought it's unroadworthy. It may be the proper analysis of that, but I just wanted to check with both of you before we left.
Well, I think your instructing solicitor is nodding, so which I can see and you can't. So I think that is. I can't. I can certainly say that your lordship's theory as to why there is that discrepancy is a completely plausible one. I don't think I can go so far as to say I know that is right or wrong, but I think it's a shared case that the claimant returns the car to Helphire and it's then off the road for the 12-day period whilst it's being repaired.
So she drove it around with a sort of slightly damaged left-hand side and lived with it. Yeah.
It appears that she did. Yes.
And there's no claim by her, even in her name, that she was actually deprived of the use of a car
because she continued to drive it. Yes, I assume.
Good. Well, thank you both very much. You've been very patient with us with a great many questions. It's a fascinating case. We will, of course, reserve judgment, and we'll let you have draft judgments in the usual way. You know the drill. to be sent out for correction of manifest errors, but not for re-argument. We are very grateful to you.
Well, we're much obliged by law.